What is the Violence Against Women Act, or VAWA, and how to apply for it? In today's Tip of the Week video, we are going to talk about this act, who can apply for it, and what is the process like. I'm immigration attorney Andres Mejer, and if you don't already know me, I'm an immigrant myself. I came to this country with my family, and for a long time, we didn't have legal status. We fought hard to get it. We were scammed by people and lawyers arguing that they were going to help us, but in the end, we only lost money and time. If there is a mistake you can make while dealing with the US immigration system, we did it at least once. And even though there were hard times, that was what motivated me to become a lawyer and help people have a smoother ride to achieve their American dream. So, the Violence Against Women Act, or VAWA, was passed by Congress in 1994 as part of the Violent Crime Control and Law Enforcement Act of 1994. This was made to recognize the severity of the crimes associated with domestic violence, sexual assault, and stalking. Today, you can apply for a permanent lawful residence, i.e. a green card, if you are the victim of battery or extreme cruelty committed by your spouse, who is either a U.S. citizen or lawful permanent resident, or if you are the spouse of a U.S. citizen or lawful permanent resident and she or he has abused your child, or if a U.S. citizen or lawful permanent resident parent, including a step-parent, or a U.S. citizen adult son or daughter. So basically, you have to be a victim of battery or extreme cruelty, and it has to be committed by one of these people. Your spouse, and your spouse is a citizen or a green card holder, or your spouse or green card holder abused your child, or your parent abused you, and your parent, even if it's a step-parent, was a citizen or green card holder, or your adult son or daughter was a U.S. citizen, not a lawful permanent resident. Now, the cases that we've had where it was your children is usually children who suffer from a mental condition, who are bipolar, who have other impulse control issues. Those are the cases that we've seen, and we've seen successfully. They are by no means the only ones. As you can see, not only spouses can use this opportunity, but the children and parents of the abuser may also seek this type of protection. You may self-petition the VAWA by filing a petition for a Malaysian widower or special immigrant. It's Form I-360, without your abusive family member's knowledge or consent. See, typically, these are family-based applications where your parent, your spouse, or your child is filing for you. However, if you suffer from battery or extreme cruelty, you still have to prove the relationship. But if you prove extreme cruelty or battery, you can file on your own. That's why it's called a self-petition. A person who files a VAWA self-petition is generally known as the VAWA self-petitioner. If your self-petition is approved and you meet other eligibility requirements, you may be eligible to apply to become a lawful permanent resident right away, or you may have to wait for a visa. There are 4 steps you need to take to get your green card on the VAWA. The first one is for both immediate relatives and preference relatives, and that is the visa petition. In this step, you'll need to prepare a petition on your USCIS Form I-360. For this petition, you must include supporting evidence such as marriage or birth certificate and proof of the U.S. citizen or lawful permanent resident status. However, because the self-petitioner must prove the abuse as well as legitimacy of the relationship, like marriage, gathering all the required evidence might take longer. The process may seem complicated, and if you are doing it alone, hiding it from your abusive family member's knowledge can be scary, but you don't have to suffer any of this. In cases like this, having the backup of a lawyer can make a huge difference. You can use another person's address, a safe address in the United States, to protect yourself in case you are still living with the abusive person. However, long-term, you should not continue living with an abusive person. It will cause you problems when you ultimately file for citizenship. At this point, the process splits in 2. The preference relatives submit the visa application to USCIS as a separate package and must wait for a visa to become available, while the immediate relatives can combine it with their application to adjust status. So, what we're talking about is a family-based application generally has 2 components. One is to document the relationship, and second is the change of status. So if you've suffered extreme cruelty, you have to document the relationship and prove extreme cruelty. Under some circumstances, you can also file for the change of status at the same time. So if you're a preference relative, what that means is The person applying for you typically is not an immediate relative, which usually means they're a lawful permanent resident. Because the spouse and child of a U.S. lawful permanent residents are not always immediately eligible for a green card, sometimes the visa is available, but often it's not. They sometimes submit a visa petition to USCIS for approval before going any further with the green card process. Upon receipt of your I-360 visa petition, USCIS will typically within 30 days issue a notice of action. It's called Form I-797. We refer to it as the receipt notice. This contains a receipt number as well as a priority date. We will talk about the priority date in the next step. Unfortunately, USCIS tends to take longer to decide an I-360 because it must review all the included evidence. Once the petition is approved, USCIS issues an approval notice. Now, USCIS approval of your I-360 does not in and of itself provide any legal status in the United States. It merely means you have completed the first step in the process of obtaining your green card and must wait for a current priority date to continue. The next step is waiting for the priority date to become current. Because of annual and per country limits on visas for preference relatives, the self-petitioning spouse or child of a green card holder may have to wait a long time, often several years, for a visa number to become available. It's a first come, first served waiting list. You're placed on that list, can be tracked using the priority date listed on your receipt notice. Until your priority date is current, you are not yet eligible to adjust your status to a green card by using Form I-485. Finally, the fourth step is to file for adjustment of status. Whether you're a preference relative with an approved I-360 and a current priority date or an immediate relative who has prepared your Form I-360, here's what you need to do next to adjust status to a green card holder. You must prepare and submit to USCIS by mail an I-485 application for adjustment of status along with supporting documents. Once you have successfully submitted your I-485 application for adjustment of status, you are considered to be in a period of authorized stay. Assuming you included Form I-765 in your adjustment packet, that's the form where you request work authorization, you will receive a work permit to last you until you get your green card. If you didn't include it, you can still submit Form I-765 along with your USCIS receipt notice for Form I-485. Within months, you will be called into USCIS office for an interview, at which time you will hopefully be approved for your green card status. Unlike regular family cases, your abusive spouse or parent or relative will not be required to accompany you to that interview. That is why it is called a self-petition. And this brings us to the end of our video. This is just a resume of how the process works to give you a bit of clarity, and you could know what to expect when filing for your green card under VAWA. But like I always mention, every case is different. It is always better to have a professional study your particular case so they may help you get the best results and avoid troubles that could lead to deportation. If you want us to take a closer look at your case, give us a call now. We will be glad to help. And if we can't help you, we won't take your money. As always, stay healthy and be well.